Okay, welcome everyone to the Firearms Research Center's virtual seminar number 17. As some of you know, we try and have a webinar or a seminar about once a month. Well, sometimes we'll post videos more often than that, but about once a month on a topic relevant to firearms. Some of those webinars are eligible for CLE, as is this one. Um, Today, we have the pleasure of having with us Professor F. Lee Francis. He is an assistant professor of law at Widener University Commonwealth Law School, excuse me. Lee joined the faculty there in 2024. He teaches constitutional law, criminal procedure, and evidence. Uh, Before that, he taught at Mississippi College School of Law. Before being an academic, he served as a federal prosecutor with the U.S. Attorney's Office. He also served on active duty as an Army JAG officer, and he is still a captain in the U.S. Army Reserves. And he will be talking to us today about drugs, guns, and the Second Amendment, the battle over 18 U.S.C. 922 G3. And with that, Lee, thank you for being here. I will turn it over to you.
Well, thank you so much, George. I do want to just briefly thank George, the Firearm Research Center, and the University of Wyoming Law School for having me. So thank you so much, and thank you all for being here. I want to get started and really jump right into the statute. Um, 922 G3. The Supreme Court is going to deal with this case in Hamani, this statute in Hamani, and we'll talk a little bit about that towards the end of the presentation. But let's talk about what 922 G3 prohibits. It prohibits the possession of a firearm by anyone who is an unlawful user or anyone who is addicted to any controlled substance. And the statute here has a couple of interesting features. One being the 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 idea that this is a status-based prohibition. They're concerned with the individual being an unlawful user as a status rather than any particular conduct. Um, so that's number one. Number two is that the language of the statute doesn't require the individual to be under the influence, doesn't require them to be intoxicated at the time of possession. And this impacts obviously controlled substances, Schedule 1 drugs, Schedule 2. But the big thing that this is really going to impact, which is the issue in the case in Hamani and many others, is marijuana. And this is significant because marijuana certainly is still banned under the federal law, but many states have legalized marijuana. And so there are certainly some issues there um, relating to the state legalization and the impact of 922 G3. The key question here, I think, for certainly the court to consider, and one of the things I want us to think about during this presentation is, can the government disarm someone simply because they use drugs? Can the federal government disarm someone simply because they use drugs? Now, as I mentioned, the Hamani case, that question of whether the government can do this is not really theoretical anymore. We are now in the space where the Supreme Court is going to confront this question head on. And the question becomes, can the statute survive following the landmark decision in Bruin? And to really understand the impact of this statute, what Hamani could mean for this statute, I think it's important to also look at what the pre-Bruin precedent decided, what the courts decided under this particular statute. And so we'll begin there. So there are a couple of cases, three cases that really um, kind of laid the foundation for how courts analyzed 922G3 offenses prior to 2022, which was the Bruin decision. The typical rationale that the courts would apply here would be that drugs tend to correlate, drug use correlates with violence, firearms plus intoxication equals a public safety risk. Those were kind of the general rationales that courts used prior to the Bruin standard. The most important piece that existed prior to the Bruin rule was this idea that the courts applied intermediate scrutiny to analyze firearms related offenses. Bruin rejects that and gives us a new test. So the first case I want to talk about briefly would be the U.S.C case that comes out of the Seventh Circuit. And the case involved a young man who was found with a loaded firearm while also in possession of marijuana. So the standard common 922G3 offense. And he also admits to using marijuana daily. Now, the court upholds the conviction here, and they essentially say that drug users can be disarmed because they are dangerous. This is the rationale that simply using drugs and possessing a firearm makes an individual dangerous. And Yancey is one of the most cited cases um, in while dealing with 922G3 offenses to kind of justify using that to justify the rationale. Um, Carter is the next case in the Fourth Circuit. And Carter is interesting because you really have a sympathetic defendant here because what they're essentially arguing is this home-based defense. This is a Heller type case where the defendant, who is a long-term marijuana user, is saying that yes, he possessed guns, but he did so in his home for his protection. Now, the court remands the case back to the lower level primarily because the government did not satisfy its burden of proving that that there was a substantial risk to public safety in Carter's case, but they said the statute would survive so long as the evidence shows that there was a risk of public safety. And so this is one of the instances where, yes, the case gets remanded, but the court still says that there could be an instance, a circumstance where 922G3 survives, so long as the government can prove that there is a relationship between the possession and public safety. The C case in the Eighth Circuit goes a bit further than some of the others. And here you have a defendant who's already on probation for a marijuana-related offense. And the government makes the argument that, well, because they're on probation, they are no longer a law-abiding citizen and would go on to argue that drug users generally fall outside of what would be considered responsible and law-abiding citizens. This language is pulled from the Bruin, the Heller case, excuse me, and the court wrestles with this a little bit in Rahimi as well. What do we make of this responsible law-abiding citizenship language? And in Rahimi, the court says, well, that's not the standard. And they reiterate that Bruin becomes a controlling law. But prior to Bruin, prior to Rahimi, these were the arguments made before the courts and the rationale that the government presented. Courts commonly treated drug users in the same way that they would have treated um, cases against felons in possession or those who were mentally ill. And so those were kind of the um, historical analogs that would have existed prior to the Bruin decision, at least in the circuit courts here. So I've mentioned the Bruin decision. I do want to spend a little bit of time just talking about the actual framework and the test that comes out of that decision. So in 2022, in the New York State Rifle and Pistol Association versus Bruin, the case deals with having to show proper cause to carry a handgun in public. And the court says that a ordinary common law-abiding citizen cannot be required to show some special need to exercise their right to keep and bear arms and their right to carry in public. And what the consequence of the decision um, was essentially rejecting the means-end scrutiny, this intermediate scrutiny that tended to develop in the courts following Heller and McDonald that courts relied on, and gave us a new history and tradition standard. And the court says, Justice Thomas writing for the majority, says that to justify its regulation, the government may not simply posit that the regulation promotes some important interest. It's not enough that the law makes sense, but rather the government must demonstrate that the regulation is consistent with this nation's history and tradition, historical tradition of firearms regulation. So we're moving away from this means-end scrutiny, this does it serve some important governmental interest, into is this grounded in the history and tradition of firearms regulation in this country. And the the court in Bruin is concerned with this idea of discretionary licensing, and so they push that out as well and say, well, no, there is no requirement for an applicant to show that there is some special need. So what Bruin gives us is really two key questions. The first is um, we ask, does the Second Amendment cover the conduct at issue? Does the Second Amendment cover the conduct at issue? The second question is, if it does, then the government has to bear the burden of showing that the regulation, the modern regulation, is consistent with historical practices. Those are the two important features that come out of the Bruin decision, which becomes the basis for this new test. So the government then bears the burden of showing that the modern regulation is sufficiently analogous to some historical regulation. And as this is played out in the district courts and the federal circuit courts, and I've even seen a lot in the state courts, where this, for example, the state of Virginia, Commonwealth of Virginia, has kind of muddied a little bit of what this burden means and will kind of force the defendant to show that the government can't meet its burden. But this really, at least as the court gives this test to us, the government must demonstrate. It's the government's burden to prove that the modern regulation is consistent, not on the defendant fighting against the statute. So the key takeaway here from the Bruin decision is that means-end scrutiny is gone. Intermediate scrutiny as a way of analyzing Second Amendment issues, that's gone. The new standard, the new test is history and tradition. History controls. And this is why 922G3 suddenly becomes vulnerable. because now the government has to prove that there's some historical analog to justify their modern regulation. Before Bruin, the question courts would ask is, does the law make sense? Is it furthering some important government um, purpose? After Bruin, the question changes. Does history tolerate the modern regulation? So after Bruin, again, these cases are continuing to be litigated. Bruin gives us the new standard, but we still emerge with a bit of a circuit split. And the constitutional fight that's really developing in these cases is, when can the government uh, disarm an individual? And so we have this status versus conduct debate. Can we simply disarm individuals because of their status as an unlawful user of a controlled substance? Or are we concerned with conduct? Are they doing something that's dangerous? And that gets us into, other more complicated, potentially complicated questions of, are we going to require a generalized determination of dangerousness, or are we going to be more specific? Some circuits will say we need an individualized determination that this individual person on a case-by-case basis was dangerous. And others will say, well, historical statutes would preventing those with mental illness would also justify preventing drug users or those who are addicted to drugs. And that becomes how the government tends to analyze these issues. Um, some of the other developments that have come up is, how close in time does the use need to be with possession? There was a case out of the Fifth Circuit, United States versus Daniels, um, Connolly. There are lots of cases that say, well, it's one thing if the person is currently under the influence, but what if they used, say, a week prior, um, but they are still in possession of a firearm, but there's no indication of active intoxication? What do we do with that? What are courts doing with that? And we'll talk a little bit more about what those cases, what some of the circuits are saying in those cases. And then the other part of the debate here is, how broadly can courts read the historical analogs? How broadly are we going to interpret prohibitions on the mentally ill? How broadly are we going to interpret prohibitions on those who simply used drugs or happen to be in what some courts will say an altered frame of mind? So those are some of the questions that um, the debates have kind of led us to. I want to talk briefly about the status versus conduct debate that has emerged in the circuits. And historically, there could be a case made for prohibiting someone's firearm use um, while being actively under the influence of, say, a controlled substance. Where there have been threats to public safety or misuse of a firearm, certainly armed violence would be grounded historically. Um, this comes up in the Rahimi case when we're talking about surety laws, going armed laws. Justice Thomas in dissent says, well, the burden, the consequence of those statutes still don't necessarily lead to um, full dispossession. It would be, you'd pay a fine or you would have to post bond. But Rahimi, the majority, says, this is sufficiently grounded in those surety type laws. Um, those would be more conduct based. The modern statutes, however, 922G3 really focuses on the individual user status. Is that individual a user of a controlled substance? Sober possession, this would be the case in Daniels, where there's no indication of active intoxication, but the individual is sober, but is also in possession of a firearm and marijuana. Is that sufficient? And in those cases where there's no indication of active impairment, the statute 922G3 does not require that. And so this is really the debate between what's sufficient historically and what the modern statutes are now regulating. And so there are a number of circuits, the Eighth Circuit, the Fifth Circuit, the Sixth, Seventh, the Third, I believe the Tenth is also involved as well, that have come to, in some cases, the same conclusion where they would say, as applied, the statute is unconstitutional, or they'll say, yes, we're going to uphold the statute based on, uh, whether there's a risk of future harm or present impairment. But not all of the circuits are really applying or using the same rationale. There are some nuances here. For example, in Cooper, the the case is about whether the government can, again, disarm an individual simply because of his drug use. And the court in that case focused on whether drug use itself actually presents a danger to public safety. Um, and can categorically, can we disarm those people based on that status? And the court kind of tries to take the middle position in the sense that, at least as it relates to Cooper and dealing with marijuana, um, that's it's not sufficiently a public safety risk. It just doesn't really seem to be enough. But perhaps there could be instances where simply one's use of a controlled substance could be um, could be upheld. And I suppose you could think about um, the person who uses methamphetamine, the person who uses um, cocaine or very serious type of drugs. Could those individuals simply based on their status as a user of those drugs be dangerous? And I think the Eighth Circuit is trying to say, well, in some cases, yes, maybe we would uphold the statute, and others we would not. But they do seem to put pressure on this categorical dispossession. That's one circuit. The Fifth Circuit, as I mentioned, the Daniels case, and Daniels, the person at least there, was sober at the time he possessed the firearm. And there were also, um, kind of remnants of the marijuana kind of in an ashtray. So he had maybe smoked at one point before, put out the buds, and that became the basis for his prosecution. I think was something like zero point 0.5 grams of marijuana or something like that. And the Fifth Circuit in that case held that the statute as applied to Daniels was unconstitutional. And the primary thrust of the reasoning came down to uh, the fact that there was no evidence of his active intoxication. He wasn't presently under the influence. Connolly comes around after Daniels, and it really is similar in the sense that we're dealing with marijuana user who is found in possession of a firearm, but the government could not show um, that Connolly was actively intoxicated at the time that she possessed the firearm. And beyond that, could not show um, that she was using the firearm in a way that would create a public safety risk. She wasn't threatening in any way. Um, and the court says, based on these facts, as it is applied to Connolly, that the statute is unconstitutional. That simply saying someone who occasionally uses marijuana um, is simply too broad of a justification. The Sixth Circuit, upholding the statute 922G3, um, takes a different approach. And there, the question becomes, can the government disarm an individual for some future harm, the future risk of harm? Well, the facts here are interesting in the sense that the defendant here was arrested while both drunk and high on marijuana, um, but had been shooting at a propane tank, um, had a number of homemade pipe bombs in his home, and again, I think it's appropriate, at least at this point, to be thinking, well, this doesn't really sound like Cooper, the person who just, occasionally uses marijuana, or Connolly, who, admits to using it sometimes. But now we have someone who uh, presents a dangerous conduct, who presents as a dangerous individual. And the court says that they're willing to uphold the statute because there is this risk of danger. However, the court still says that we're going to look at this dangerousness inquiry on a case-by-case basis. And the question that they're going to ask is it clear that the defendant poses a risk of harm to others? Now, Van Ogden is kind of the easy case for the government. You have active intoxication, you have reckless use of a firearm, you have evidence of what would really be considered concrete danger. And so it seems like, okay, well, this is the easy case to uphold. Well, some of the circuits that uphold the statute um, look at other factors as well. In the Seward case, you have someone who is currently under the influence. The court rules based on the present impairment. And they also go on to say that that impairment then creates a concrete risk. It creates the public safety concern. Now, the case does not involve marijuana, but it does involve use of cocaine, which would have just been, fairly close in time to the possession of the firearm hours. Um, there's evidence that Seward used heroin on a daily basis. Um, and so this looks more like, okay, this individual is currently actively under the influence of something, controlled substance. And so there's a stronger link, arguably, from the historical analogs of punishing individuals who are actively intoxicated to the cases presented at least now in the Sixth and Seventh Circuit. And so again, a little bit of a easier burden for the government to prove based on those instances. And there the court says that, again, some applications um, of 922G3 will survive if the government can point to present active intoxication. Or, as the case of Van Ogden, some particularized evidence of danger. Is it uh, objective? Is it reasonable that this individual actually poses a risk of harm? Now, Harris is a little bit more complicated. Coming out of the Third Circuit, the court, as I say, upholds 922G3 in principle, but there's still a little room here for defendants to make their case. And the case involves um, the government kind of pointing to historical analogs. And the question becomes, has Harris demonstrated that they were a danger to the public? And it kind of takes this middle of the road approach. The government isn't able to prove that Harris has presented some special danger, some public safety. They don't have enough facts to support that. And so the court says there could be a case where you can identify an individual, show that they are dangerous, that they present a threat to public safety. Um, and perhaps in those cases, 922G3 could be upheld, at least as it related to Harris. The court says there's just not enough evidence here. There's not enough in the facts to justify um, the case as it relates to Harris. They remand it, but 922G3 still survives. But it survives with the caveat that there needs to be some individualized showing of dangerousness. So if Seward is the easy case, active impairment, Van Ogden, active risk of harm, those are the easy cases for the government. Um, Connolly becomes certainly difficult. Then Harris really kind of falls in the middle. Um, that there needs to be more. The common theme in the circuits became tying possession um, of a firearm and intoxication to those historical intoxication laws, applying the historical dangerousness um, analysis, where they're looking at loyalty laws or looking at oath, where instances where individuals refuse to swear an oath. We can certainly debate about whether or not those are appropriate analogs, but those are the decisions that the circuit courts are relying upon. And then, of course, again, the dangerousness aspect. The circuit splits the broad readings of historical analogs, produces this division that then makes Hamani so important. Um, Hamani looks a lot less like Seward, Van Ogden, and a lot more like Connolly. Um, and the circuit splits here is exactly why the Hamani case is so important. And it shows that the court, the Supreme Court now, is not stepping into a relatively settled field. No, not at all. They're stepping into um, a doctrine that really has been fractured uh, following the Bruin decision. And it centers on this question of can the government simply disarm individuals because of their status and their status alone? So in that sense, the Hamani case really isn't just another 922G3 case. It's a lot more than that. It becomes a vehicle for through which courts can decide, what are we doing with status-based dispossession? Does it survive under the Bruin standard? And this really would have an impact on other 922G3 offenses. So why does Himani matter? Well, again, we talk about the status-based dispossession. The court may have an opportunity to clarify whether dangerousness is actually required in these types of cases, um, and uh, has the potential really to impact um, statutes in cases that go beyond simply using drugs or controlled substances. So what happens if Hamani wins? Well, there are a number of things that can happen. In this case, just for background, Hamani again is they have a warrant. They're investigating him. They enter his home. They find marijuana. They find firearm, and I believe they also find some small amounts of cocaine. But the case comes to the Supreme Court solely on the marijuana possession with the firearm. And I mentioned before about what do we do with dangerousness? If Hamani looks more like Connolly and less like Van Ogden or Seward, what is the role of dangerousness um, in the statute in these types of cases? Well, there's been some debate about this. Now, the government's position would usually be that, well, simply using an unlawful substance, the impact of that substance can make an individual dangerous by using drugs, is what the government will sometimes argue. Um, the government will argue that the intoxication laws, historical intoxication laws, uh, prohibits possession. Surety laws. The government will find a lot of things to make their argument, but as we saw in Connolly, as we saw in Cooper, those are not necessarily best analogies or best analogs for the government to use. The defendant side of this says, no, we need active intoxication, active dangerousness. And so it's not simply enough that an individual uses drugs. It's not enough that they use drugs to make them dangerous. Now, I've argued in a paper called Defining Dangerousness that the test really should be focused on significant and imminent risk of unlawful violence or harm to an individual. It needs to be concrete and particularized. There needs to be evidence of this danger. It's not enough that someone's status would justify their disarmament. And so dangerousness, as I argue, must be grounded in conduct, not status. And that tracks with the historical understanding. So what happens if Hamani wins? Well, the unlawful user portion, at least, of 922G3 really becomes unenforceable, at least in its current form. It's possible Congress can add in a dangerousness element, um, but that becomes a certainly more difficult case to make from the government's perspective. Um, Cases that are currently pending on 922G3 would likely be dismissed. Um, and this impacts millions of individuals who use marijuana specifically, both in the legal state context and also in the federal context, where now simply being a user of marijuana does not subject someone to uh, federal firearms prohibitions on under 922G3. The other thing is courts would really have to wrestle with what happens to status-based prohibitions after Hamani. Um, so I would say the key takeaway here would be that the Second Amendment, the doctrine shifts more toward conduct-based dangerousness rather than simply being an unlawful user or simply being someone who uses a controlled substance. So there are a couple of other things I think practically that the government would consider if Hamani wins. Um, I think the next step would be um, what happens to state laws where there is no requirement for active intoxication? And it looks similar to 922G3. The Virginia Supreme Court is taking up a case very similar to this. Do those state offenses now also fall away, applying the same analysis in Hamani? I think there are a couple of just kind of practical litigation strategies that could come up. For example, forces the government to really bear this burden of finding appropriately relevant and similar historical analogs. And in the event that they can't, these as applied challenges are really going to make the government's case very difficult. Um, and certainly when they're trying to argue these status-based prohibitions and versus conduct-based, which is what I think the defense will be arguing for. I think there are a number of things that perhaps could, really take immediate effect after Hamani, um, if 922G3 is struck down. Um, Post-conviction relief is another thing that really starts to come back. Courts are going to have to deal with this again. It's not clear what happens to the second part of 922G3, this addicted to prong. Certainly the government's going to have a lot more um, evidence. They're going to have a lot more evidence to make this case that the person is actually addicted um, to a controlled substance. And I think that makes things particularly more difficult for them. There are not a lot of cases that really fall under that second prong. Majority of 922G3 offenses fall under the unlawful user prong. So it would certainly be interesting to see, does this statute have life at all um, if the court strikes it down? That is the bulk of my talk. I do want to leave room for questions um, if there are some, and I'm happy to yield to questions at this point.
Thank you, Lee. Thanks very much. Just so everyone knows, and for the folks joining us for the first time, if you have any questions, please do put them into the Q&A feature of Zoom, and then Lee can see them and I can read them to him as well. Um, a question we have is whether you would be kind enough to kind of restate your your thesis on dangerousness and when being a danger or being dangerous is sufficient to take away someone's rights or to disarm someone, and and then maybe how that, I'm kind of adding on this second part myself, how that relates to various forms of intoxicant use.
Sure. So my claim, and this is um, something I've spent some time trying to think about, is under my formulation, dangerousness. Um, the government must prove that there is a concrete and particularized danger, that this is really an individual case by case basis, that the individual has a significant and imminent risk of danger to others, that it has to be uh, based on their conduct. This could be, for example, Rahimi would be the easy case where you have someone who is, kind of the court says cartoonishly violent. He's shooting people, people in the street. He's, in this tussle with his girlfriend. So that would be clearly violent and imminent and significant risk. Simply using, say, for example, cocaine under my formulation of dangerousness would not be enough. Um, that there needs to be some kind of conduct that would justify dispossession. And I think that that tracks with the historical framework for uh, dispossessing an individual.
Gotcha. Okay. Sort of a question, not necessarily for you. Excellent and clear analysis. Thank you. Can you provide slides/handouts to use when requesting CLE credit? I can answer that one. The answer is yes. The slides will be on the event page, the FRC's website on the event page, and I will give you a link to that page now. The slides aren't up there yet, but they will be. And a link to the Wyoming CLE approval page is there as well. So I believe yep, there it is. That's so you'll be able to find that there fairly quickly. And the reading material is also linked from that page.
I do want to say another thing because I think it's really important to stress what the ripple effects that Hamani could have on other 922G provisions. For example, the 922G1 felon in possession, the prohibition of individuals with mental illness. Um, if we're really going to say that status-based prohibitions are wrong, then, someone gets a felony when they're 19 for marijuana possession, say, um, 40 years later, they're in possession of a firearm. They're not dangerous. They are, upstanding members of the community, but they want to be able to protect themselves because they live in a bad neighborhood. Um, is that, the kind of status prohibition that we're still going to permit after Hamani? And I think certainly the rationale that comes out of this case would impact the 922G1 offenses, which I think are already kind of on the chopping block. Um, Someone has generalized anxiety disorder. They have a mental illness. They're not currently involved in any mental health episodes. They're not experiencing any psychosis or anything. They just have anxiety. Is that a justification for that status? Is that enough for depriving someone of their right to bear arms? And again, under my framework, the answer would be no. And I think the court's rationale in Hamani really kind of opens up those cases to a lot more scrutiny.
Gotcha. Okay. Another question just came in. How do you suspect the government in Hamani will reconcile the constitutional inconsistency with Robinson and Powell, given that this is a clear status offense?
Uh, I'll have to say, Robinson and Powell, I would need a little bit more. I don't know if I'm familiar with those cases.
Okay. We'll let our colleague type more if he'd likes if he'd like. Here's a question asking you to read the tea leaves, and
Hmm.
I always say before I start speaking, I'm reluctant to read tea leaves, but care to guess how the court will decide Hamani, how the court will split?
Oh gosh, I gave a talk with the FedSoc group about this, and I say at the beginning, I am usually wrong when I say this. I think um, I think this could be more of a 7-2 decision. I think Justice Alito is clearly going to write a dissent here. The U.S. attorney kind of came out of him during oral argument where he's like, why can't we just put these people in jail? What's the big deal? Um, and it seems as if um, I think, he will probably have maybe one other vote. The Chief Justice does seem to be a little bit suspicious, but it's possible, considering how he likes to be in the majority, that he may find his way into the majority. Um, but at the very least, I think it's 8-1, possibly 7-2 with the Chief Justice if he chooses to really be in dissent here.
Got it. And by that you mean a win for Hamani in this
That's
case.
right. That's right.
Gotcha. Gotcha. Okay, more on just in time, more on Robinson. In Robinson, the Supreme Court found that criminalizing drug addiction as a status violated the Eighth Amendment.
Mhm.
Even as this narrow application narrowed in Powell, parentheses, i.e., the court found those addicted to alcohol can still avoid public places while intoxicated and therefore remain culpable despite their addicted status. The
Mhm.
Supreme Court remained consistent that conduct must be the central consideration for the criminalization of activity rather than the status of the individual. Thank you for that.
Yeah, well, thank you. I think the I think the issue in the Second Amendment context is that we don't have enough in the Second Amendment we don't have enough case law. There's certainly academic discussion, but I think the court um, doesn't quite know how to reconcile those two yet. I haven't seen a lot of this discussion in the circuit courts. I have certainly not seen it on the state court level. Um, but I think certainly focusing on someone's conduct would be consistent. Um, the same thing is true in the First Amendment context. We want to know, you could say all kinds of things, but at the point that your conduct, your speech becomes threatening, then the government can step in. But simply just saying something may not necessarily be enough. And so I think there's still some development happening here. Um, and I can't say for sure how the Eighth Amendment context will square with the Second Amendment, but my argument would be, well, we really do need conduct-based justifications and not just status. So hopefully that answers the question.
Yeah, I think so. All right. Does anyone have any other questions for Professor Francis? Okay, Lee, do you have any closing remarks? Any other points you wanted to add here before we wrap up for the day?
Just a few. I mean, I think that, the work that the Firearm Research Center is doing, the NRA, there are lots of scholars who are talking about these issues because there's not a lot of information, at least case-wise, on the Second Amendment. This is really a fascinating opportunity to kind of, witness the development of the law in real time. And so, 922 offenses are certainly going to be coming back to the Supreme Court. State offenses will be coming back. That this is a really interesting time for Second Amendment jurisprudence. So I'm thankful that you all are here and happy to be a part of it.
Great, great. Well, thank you, Lee, very much for joining us today.